All right, this will be the last one, I'm sorry.
Take 3.
All right. My name is Pete Robinson. Welcome. I'm a financial advisor, financial planner here in Westerly, Rhode Island. And I'm here with my friend Matt Mercer, a state attorney. Matt, can you tell us a little bit about yourself?
Sure.
Get started.
Sure. My name is Attorney Matt Mercer. I am a trust and estates attorney and elder law attorney with the law firm of Chace, Ruttenberg, and Freedman. We have an office in Providence, Rhode Island, and we have an office here in Westerly, Rhode Island. And I'm from Ashaway, Rhode Island, which is about 5 or 10 minutes outside of Westerly. And I'm licensed in Rhode Island and in Connecticut.
Well, I'm glad you didn't go to the big city, stuck here in a little town with us. So, a lot of people are intimidated by this type of process. They don't deal with attorneys much, and it's a subject matter that is not something that's really appealing, thinking about our incapacity or eventual death. But these are things that I try to tell my clients that you got to grin and bear it and talk to someone such as yourself. So, how does someone get started, and what are the things to think about while we're still alive and when we eventually pass on?
I would say start simple, and this is what I would start with. Take a look at your assets that you do have and ascertain, do I have proper beneficiary designations on these assets?
Okay.
If you have IRAs, 401ks, people invest in retirement accounts.
Yep.
And I can't tell you how many times we have to go through probate because someone has not added either a primary or a contingent beneficiary on their IRAs or life insurance policies. So that's starting simple.
Yep.
From there, I would start with what we call the incapacity or living estate planning documents.
Okay.
Your medical proxies and a financial and legal power of attorney. And again, those are the forms that if I'm incapacitated, if I'm cognitively incapacitated during my lifetime, I have someone that can make medical decisions for me, usually a primary agent, and someone that can make financial and legal decisions for me as well.
And this is something that can happen to all of us, no matter what kind of shape you're in, your medical situation. We can all become incapacitated. God forbid we don't, but it's possible for all of us to get into a car accident.
Right.
I know HIPAAs are there to protect the privacy of the people, but just because you're a family member doesn't mean you'll get the information without the proper documentation. Is that correct?
Okay. Correct. So I recommend 4 documents, and I'll go through those with you. So number 1, what you alluded to a minute ago, was the HIPAA waiver and authorization. The HIPAA form is going to allow the doctors, nurses, hospitals to release your private healthcare information to the people that are enumerated on that form.
Okay.
And knowing the situation of what's going on with your loved one is enormous. You want to know what's the prognosis. So that's number 1.
Yep.
Number 2 would be a medical durable power of attorney.
Okay.
If that person cannot communicate his or her wishes, if they're unconscious, you have to have a form nominating an agent to make medical decisions for that person.
Okay.
Number 3 would be a living will. A living will is a document where, I'll pick on me, I am memorializing my wishes for end-of-life decisions. So if I'm sick, there's no reasonable expectation of my recovery, I don't want to be kept alive indefinitely on artificial life support systems.
Okay.
So those first 3 documents are your medical advance directives. The last one deals with financial and legal decisions. Similar to the medical durable power of attorney, we are appointing a person or persons to make financial and legal decisions for that person.
And again, just because you're a family member or a spouse doesn't mean that this account or that account representative is necessarily going to talk to you.
Correct.
And that can be a real sticking point if you need money.
Yes.
Or you need to make decisions.
Yes. Okay. The takeaway from having these forms in place is if something does happen to your loved one, and they are in a situation where they're, God forbid, permanently incapacitated, we don't have to go through a court process called guardianship or living probate,
Okay,
okay, or in Connecticut, conservatorship.
okay,
And that's something generally that we want to avoid. It's expensive, it's time consuming, and it also usually creates a fair amount of stress in the family.
that's when you're living, and it seems like we all should have those types of documents. And we've all heard of wills, and we've heard the term probate. Can you kind of walk us through how the will and the probate process works for most people?
Sure. So a will, just as sort of a 50,000 foot view here,
Yeah.
is only going to control the assets that the decedent owned in his or her name at the time of their death. A
Okay.
lot of people think that the will universally controls the disposition of all my assets, and you know that's not true. If you have assets that have beneficiary designations on them or are jointly owned, that beneficiary designation or the joint ownership will legally supersede what's in the will. So the will, again, is only going to control assets that the decedent owned in his or her name. The process is basically a process that is designed to protect creditors and or legal heirs, and it's designed to administer the decedent's assets and distribute them to either the beneficiaries that are enumerated under the will, or if the decedent did not have a will, there is a statutory will that each state has that dictates if these persons are your surviving heirs, either children, siblings, parents, they are the persons that will be legally entitled to receive your assets.
So say I pass away, I own a house in my name, I own a couple cars in my name, and I own a savings account in my name. Would those have to be listed in the will, or is it just the fact that I own them that kind of takes care of it?
Yeah, the fact that you own those assets, they would be distributed under what we call the residuary distribution clause of your will. It would distribute your assets at the time of your death, because
Okay.
we don't know what you're going to own.
Right,
at
yeah,
the
yeah,
time
so
of
it's
your
not
death.
like you have to modify your will every time you get a new
Correct.
car. or-
Correct.
Okay, gotcha,
Correct.
okay. Probate is something that is required if you have a will. Can you give us a rough time frame on what that process looks like, time-wise at least?
Sure. In Rhode Island, there's actually two forms of probate.
Okay.
There's what we call small probate, that if the decedent's assets were under $15,000, it can be a matter of weeks before the beneficiaries can actually receive those assets.
Okay,
If it's a full probate and the assets are over $15,000, it's going to be a minimum of 6 months before the estate can be closed
Okay.
and the assets can be distributed to the beneficiaries.
which can be a hardship in certain situations.
Sure.
Okay,
And with the probate process, the persons under the will, the beneficiaries, are entitled to notice. They have an opportunity to come into the probate court, and if they disagree with the terms and provisions of the will, the probate court is their forum to essentially file a grievance, if you will.
so one of the things that when my dad passed a few years ago, he had, this was not a legal document, but he just had his wishes written down on a little notepad, which I took a picture of soon after he passed. I want an obituary in the Bangor Daily. I want, I don't want an open casket, and all these things. So that seemed really a big stress reducer for the family because he knew what was going on.
Right.
And credit to my dad for doing that. But is that something that I assume you would recommend as well? Is something along that line?
Yeah, and that's sort of at the foundation with beneficiary designations
Okay.
and the living estate planning documents, communicating your wishes to your loved ones about your ultimate demise. It's going to
Okay.
happen to all of us.
Yeah.
Do you want burial? Have you thought about what you want included in your obituary?
Biggest question I get, I'd say, from clients is, hey, Pete, do I need a trust?
Mhm.
Can you talk a little bit about that for, the quote-unquote regular person? It doesn't seem like there's a one-size-fits-all approach, but can you think of some things to consider when you're evaluating whether you need to have a trust or not?
Yeah, it's good to talk about the three basic types of trusts.
Okay.
A basic type of trust that a lot of people will have, a younger couple, when they go to see an estate planning attorney and they're doing wills and they have minor children, is a testamentary trust. We do not want our children receiving the inheritance until X.
Okay.
A testamentary trust is a trust contained under a will, and it only comes into play at death.
Yep.
Number two would be a living revocable trust. Essentially what that is, it's a fancy will. The primary purpose, or I should say a baseline advantage of the living revocable trust, is we avoid the probate process.
Okay.
We avoid the time constraint, the public record,
Mhm.
and the legal fees and court costs associated with the probate process.
Okay. Yep.
And then the final one is an irrevocable living trust. That is a trust that we typically use in more sophisticated circumstances. We're trying to avoid paying death taxes.
Okay.
We are doing some charitable planning.
Mhm.
We are trying to insulate assets for nursing home protection or veterans planning.
Okay.
So, but when you drill down on it, there are three basic types of trust. Testamentary, under a will.
Mhm.
Living revocable, meaning you can change it during your lifetime.
Yep.
And the baseline advantage is probate avoidance. And then an irrevocable living trust.
Okay.
That once it's created, the person that is creating it cannot revoke it and cannot terminate that trust.
Okay.
And they are typically forfeiting control of the assets that go into that trust.
So just to wrap things up, this is not a one-size-fits-all approach. The only way to really tackle any kind of problem in your financial or estate planning lives is just to do it.
Right.
Start the process.
Right.
So if I'm going to come see you or someone like you, what do I need to have ready, at least for the initial conversation about where I'm at?
It's probably pretty similar to your process, Pete. I would need sort of a general family overview.
Mhm.
I would need to know just a ballpark of their assets. I would need to know whether they have real estate interests.
Okay.
Maybe they have a primary residence, maybe they have a vacation home, and then we would kind of go from there. What are their objectives? When I sit with a client and I meet them for the first time, why are you here? There's a reason that maybe it's your financial planner that spoke to you. Maybe it was a situation that someone else went through. What are your objectives that you're trying to implement by putting this estate plan together? And I feel like that is really the most important way to start the meeting.
So you don't need to come in knowing that you need a trust or knowing this or knowing that. You just
No.
need to know what your wishes are and kind of what you have.
Correct.
Okay.
Correct.
And you help figure it out.
I do.
Okay.
Yes.
Matt, I appreciate your time. Hopefully we can do this again.
Thank you.
All right.
Appreciate it.
All right. Bye-bye.